Good day, ladies and gentlemen. It is with great pleasure and honor that I welcome you to our SST 213 conference, an event that brings together brilliant minds and experts from various fields to engage in a shared exploration of ideas, innovation, and progress. I am Jaira May Hangad, the second reporter of Group 2. Our group topic is Chapter 7, The Judicial Power and the Judiciary, and Mr. Kutab already discussed the introduction of a topic. And for today's topic, I will be discussing the problems in the Philippine courts. Before anything else, let me first read the objectives of today's topic. First, understand the reasons and effects of the vacancy in the judiciary. Second, examine case disposals of different courts. Third, determine the procedures for membership in the judiciary. Let's start with a vacancy in the judiciary. So, from the word vacancy, it is the state of being vacant, or in short, emptiness. That means that there is a vacant position within the judicial system. May it be an open position for a judge kung saan sila yung nagpe-preside over legal proceedings and nagdidesisyon on legal matters. Open position for a justice. Sila naman yung nag-handle ng specific legal matters such as pag-issue ng warrant, conducting arraignments, and presiding over certain types of cases. There are many positions na maaring vacant sa judiciary. As you can see in the table, these are the vacancies in the different courts of the Philippines as of 2010. So in the highest court, which is the Supreme Court, walang vacancy. Sa middle-level courts, which includes the Court of Appeals with a vacancy of 7, the Sandigan Bayan with a vacancy of 1, and 0 vacancy sa Court of Tax Appeals. Sa lower or trial courts naman, the highest vacancy is the regional trial courts with 207 vacancies. Tapos sumunod ang municipal circuit trial courts with 160 vacancies. Then the municipal trial courts with 100 vacancies, and so on. Based on the 2010 annual report of the Supreme Court, the vacancy rate in the judiciary is 25.6%. Or 586 vacancies out of the 2,320 judicial positions. Now, bakit nga ba ito nangyayari? Well, there are many reasons behind it, either due to retirements, resignations, promotions, creation of new positions within the judiciary, or maaring yung constitutionally created body, just like the Judicial Bar Council or JBC na in charge sa membership ng mga judicial positions ay slow in filling up the vacancies. Later on, we will also discuss the membership in the judiciary and I will be mentioning that JBC. Now, ano naman yung magiging effect nito if these vacancies will continue to increase? Well, because of this major problem faced by the Philippine courts, which is the lack of justices and judges, maaaring maapektuhan yung delivery of justice sa mga tao. Nagkakaroon ng delays ng cases and there will be more pending cases din. As you can see in the table 25, this is the Supreme Court's case disposal as of December 2010. The table includes the en banc or on the bench. Ito yung special procedure where all judges of a particular court hear a case. The first division, which is headed by the Chief Justice, the second division, which is headed by the most senior associate justice, and the third division, which is headed by the second most senior associate justice. And as you noticed, mayroon ditong case input, case output, and percentage of case disposal. Case input refers to the initial stage when a legal matter is brought to the attention of the court. Dito yung filing of legal documents, complaints, or petitions that initiate a case. Case output naman refers to the outcomes and decisions reached by the court during the course of the legal proceedings. Dito na nangyayari yung judgments, verdicts, orders, and any other formal decisions issued by the court. At ang case disposal, this means it has been closed. A case being closed can include dismissal, conviction, and admission of guilt among other reasons. So in en banc, as you can see, mayroong judicial and administrative matters. Judicial matters are legal processes where a judge decides what should happen, while administrative matters are legal processes that don't involve a judge. Usually, they're carried out by a government body. Example cases of judicial matters are criminal cases, family cases just like divorcing of married couple, etc. Example cases of administrative matters naman is licensing and permits, immigration issues, and etc. Now, based on the table, the disposal rate of cases in en banc and in divisions was between 50 to 68%. Parang half ata yan ng total cases filed in the court. The bulk of these cases were judicial matters or regular cases filed for decision or under review by the court, except in en banc administrative matters which deal with civil service and legal procedures in running the government constitute less than half compared to judicial matters. In the first division, for instance, there are 4,479 judicial cases, but only 1,342 administrative cases. As a whole, the disposal rate of the Supreme Court was only 62% of all the cases filed for decision and review. Now, I have a question. Is it time to revise our constitution and increase the number of justices in the Supreme Court to keep pace with the increasing population and legal cases filed in all courts in the country, which will most likely end up in the highest court of the land for review? If yes, it is very complex kasi there are factors that we need to consider. Next is Table 26, which is the middle level and lower courts case disposal as of December 2010. Compared to the Supreme Court, the middle and lower courts move even slower in their disposition of cases. The middle courts, which consist of the Court of Appeals, sila yung General Appeals Court for regular criminal, administrative, and civil cases. The Sandigan Bayan, the Trial and Appellate Court for criminal and graft and corruption cases committed by the public officers, and Court of Tax Appeals, which is the specialized appeals court on taxation cases. The middle courts and lower courts, which consist of all trial courts in the country, have a similar disposal rate of cases of 38%. In the middle courts, as you've noticed, the slowest court is disposing of cases in the Sandigan Bayan with a dismal 10% disposal rate. As of December 2010, 2,405 cases filed in court, only 247 were decided, leaving more than 2,000 cases pending. This is very ironic kasi the Sandigan Bayan, as what I've said, sila yung court for criminal and graft and corruption cases, and it is expected na mag-speed up yung legal proceeding dito para naman ma-discourage ang public officials to steal from the government. The Court of Appeals naman emerged as the highest disposal rate among the middle-level courts. But this 40% disposal rate is still slower than that of the Supreme Court. Among the trial courts, the regional trial courts, a regular trial court for serious offenses and civil breaches, the largest number of trial courts in the country, manifest a low disposal rate of 33%, much lower compared to the Supreme Court and middle-level courts. All I can say is that this is really a reflection of the slow justice system in the country, as you all observe from the given tables. Grabe talaga yung rates of disposal cases. Of course, there are reasons naman talaga behind these rates. Aside from the lack of justices and judges, some lawyers deliberately delay cases to earn more appearance fees in court. Appearance fee is a compensation paid to professionals in the court to acknowledge the time, effort, and the participation in the legal proceeding. Others delay the proceedings, hoping that the case will end up settled outside the court, just like negotiating or having an agreement to settle things na lang. The municipal courts, especially the Metropolitan Trial Circuit courts, with a 53% disposal rate, Metropolitan Trial Courts with 45%, and municipal trial courts with 40% showed a relatively faster rate compared than the middle-level courts. But the municipal circuit trial courts were the slowest among the municipal and metropolitan courts with a 32% disposal rate. We must consider this type of court kasi this is usually found in remote regions or provinces in the country, kaya mas more yung vacant positions for judges dito. The Sharia courts for Muslims handle less cases compared to the regular courts, but the Sharia district courts have the slowest disposal rate of 15% compared to all the courts in the country. Now let us proceed to the membership in the judiciary. So the membership in the judiciary is through these three important things. First is the integrated bar of the Philippines. Second is the qualifications. And lastly, the Judicial Bar Council or JBC. Let me first discuss the Integrated Bar of the Philippines. Unlike the educational qualification of the President, Vice President, Senators, and Congressmen or women, which requires only the ability to read and write, and nakabase ito on the Article 7, Section 2 of the 1987 Philippine Constitution. The members of the judicial branch must be licensed lawyers or members of the Integrated Bar of the Philippines. IBP is an official organization of all Philippine lawyers' names appear in the roll of attorneys of the Supreme Court. Its duty is to mandate membership of Filipino lawyers. Now, why is this so important? Well, the judicial work of justices and judges requires litigation, which is a specialized type of work. The work of members of the judiciary is very technical, kaya it requires a special education in law schools, and you need to pass the bar examination. The president, vice president, senators, or congressmen can always avail the services of a lawyer to perform the technical legal work for them. In the judiciary, the justices and judges must render their own decisions or judgments on legal cases, and thus he or she must be knowledgeable of the law. Although they can have a staff of legal researchers composed of lawyers, as in the case of justices of the Supreme Court, judicial decision based on sound judgment of the facts of the case requires the personal expertise of the justice or judge. Next is the qualifications of the members of the judiciary. This is according to the Article 8, Section 7 of the 1987 Philippine Constitution. These are the categories: sources of authority determining qualification, citizenship, age, education, experience, and moral fitness. For the justices of Supreme Court, the qualified member must be a natural-born Filipino citizen, at least 40 years old, a lawyer and a member of the bar, at least 15 years as practicing lawyer or judge, and a person of proven competence, integrity, probity, and independence. The source of authority determining qualification is the 1987 Philippine Constitution, specifically in Section 7, Article 8. For the justices of lower collegiate courts and judges of lower court, the qualified member must be a natural-born Filipino citizen or a naturalized Filipino citizen, a lawyer and a member of the bar, and a person of proven competence, integrity, probity, and independence. The source of authority determining qualification is the 1987 Philippine Constitution and by qualifications prescribed by the Congress. Next is the Judicial and Bar Council and the nomination and selection of justices and judges. In the 1935 and 1973 constitutions, the selection and appointment of justices and judges were left entirely in the hands of the President. Kaso, ang nangyayari ay mas kinukuha pa yung mga may political and social connections kaysa dun sa pasok talaga sa qualifications. As a result, some justices and judges who are incompetent and lack personal integrity, probity, and independence are appointed to the judiciary. The framers of the 1987 Constitution were aware of this problem when they set the qualification and the selection process for the members of the judiciary. Kaya to assure that members of the judiciary were highly qualified and competent, they established a special body known as the Judicial and Bar Council, or JBC, to test, to screen, and nominate candidates to the President. Normally, ang JBC ay tumatanggap ng mga aplikasyon para sa mga bakanting posisyon sa judiciary kumpara sa mga hukom. After that, sinusuri nila ang mga application sa pamamagitan ng paghingi ng mga rekomendasyon at pag-i-interview sa mga aplikante. Out of many applicants, JBC will comes up with a short list of 3 nominees which they send to the President for his choice of appointees. So parang for screening and nomination ang ginagawa ng JBC, but the President will make the final decision. But with this procedure, meron pa ring political influence coming from Malacanang kasi the President can do maneuvering, influencing the members of the JBC to include in the short list his or her preferred nominee. The President can refuse to choose from the list and can ask the JBC to give another list which might include his or her preferred candidate. It's because yung system does not state na hindi pwedeng i-reject ng President ang list na binigay ng JBC. That's why the President can ask for another list. 'Di ba? Even sa judiciary, hindi pa rin maiiwasan yung tinatawag nating backer. Another thing kasi why this happened is because the president can benefit from it. A nominee who is close to Malacanang, especially for a position in the Supreme Court, can provide the president with an important connection in the highest court of the land. Pending government cases as well as cases which may be filed against the president when he leaves office can get additional support in the collegiate body of the Supreme Court. The more justices friendly to Malacanang, the more the president can control the supposedly independent and co-equal body in the government like the Supreme Court. Now, that's the reality. Next, as you can see in the table 28, this is the function and composition of the Judicial and Bar Council. The supervising body is the Supreme Court of the Philippines. Gaya ng sinabi ko kanina, their principal function is to recommend appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it. Ito naman yung composition ng Judicial Bar Council. Ex officio chairman is the Chief of Justice of the Supreme Court. It is someone who becomes the chairman automatically because they hold a particular office, and that's being the Chief of Justice ng Supreme Court. Ex officio secretary is the clerk of court for the Supreme Court. And these are the members: Secretary of Justice as ex officio member, Representative of Congress as ex officio member, Representative of the Integrated Bar, a Professor of Law, a retired member of the Supreme Court, and a representative of the private sector. The salary of its members may be determined by the Supreme Court, tasked by the Constitution to provide in its annual budget the appropriations for the Council. So I think that would be all. Thank you for being part of this incredible journey.